Supplementary 1. Item number 1, pronouncement of judgment.
Just operate part. Resultantly, this criminal appeal succeeds. The MP on judgment and order dated 9/12/2023 and related sentence dated 22/12/2023 passed by the National Special Judge Poxo Rivo and Nongpo in special Poxo case number 34/2015 are set aside in request. The appellant is set at liberty forthwith if not required with connection with any other case. Criminal appeal stands allowed.
Any mention?
May I please, Your Lordship?
Yes.
Your Lordship, I beg to maintain item number 16 and 17, Your Lordship.
Yes.
I pray for 2 weeks' time, Your Lordship.
No objection.
No objection. 16, 17 at the request.
Much obliged, Your Lordship.
Lordship, I beg to mention item number 11 and 12 for 2 weeks, Your Lordship. So,
Other side? Same order. 2 weeks. Yes.
And I'd like to mention item number 7 of the main list, Lordship. Bring for 1 week's time, Lordship.
Which is the other side? Item 7?
Item number 7, Lordship.
Mr. Sulai, is there?
Then if 7 is mentioned, Your Lordship, then 5, 6 will have to.
Who is appearing 5 and 6?
5 and 6, Mr. Sheikh is there.
These are what?
Lordship, I am from item number 4, 5 and 6, Lordship.
So?
And for the respondent number 6, Your Lordship, item number 5.
Then you will have to.
Your Lordship, the
Why these are connected, Mr. Sulai?
Lordship, this relates to the appointment of Hindi teacher.
Then why so many petitioners here?
Lordship, because some of them are claiming salary and all. So it is linked to that, Your Lordship. One, if this court comes to a finding that there is no such, then they will not be entitled to the salary.
It's 2018 matters. Yes, that's what the problem is. Yes.
Lordship, may this matter here for 2 weeks, Lordship.
2 weeks. Okay, just 5, 6, and 7 all at the request made on behalf of the petitioner and not objected to by the learned counsel. The claim of the respondents. This is matter for 2 weeks. Yes.
Oblige, Your Lord.
Much obliged.
Please, Your Lordship, I beg to mention item number 23 for 2 weeks. Since the petition is on leave. Hello.
Who is on leave?
Mr. M. Sharma.
Okay. When do you want it?
After 2 weeks, only.
I'm for the petitioner, my lord.
You are for appearing for?
I'm for the petitioner.
I'm for the. Oh,
You are making a request on behalf of the petitioner.
apologies, ma'am.
I'm for the petitioner.
Yes.
Your Lordship, on the last occasion, has directed us to find out, my lord, when was the date when the written statement was lapsed, my lord. So we have find out from the lower court record, my lord.
So you are ready for hearing on the matter?
My lord.
After 2 weeks, ma'am. After 2 weeks.
Why after 2 weeks?
Okay, my lord, if they are not ready. Nothing much, my lord. Only the some clarification.
What is your difficulty then? Mr. Shen is not here.
He is here, ma'am.
Then? If they are ready, petitioner is ready, why should you take time? Anyway, we'll just. So, just we'll have it after 2 weeks.
Okay.
Okay.
The request, I know you have the respondent. List matter after 2 weeks.
May I have a please, Your Lordship? I beg to mention item number 15, Your Lordship. I'm praying for 2 weeks time, Your Lordship. Conducting counsel is out of station. 15.
We have no objection. 2 weeks at the request meeting of the petitioner. Yes.
All right. Similar prayer for item number 19, Your Lordship.
Yes. Same. 2 weeks.
Two
The
weeks,
19 who is the other side? Yes,
Mr.
Mr.
H. Karmian.
No problem.
No.
19 also. 2 weeks at the request. Yes.
I'll oblige.
Your
Yes.
Lordship, I beg to mention item number 24.
Item
24. Your Lordship kindly allowed 2 weeks of time.
24.
Yes, Your
You are
Lordship.
making a prayer on behalf of the
Espantri. Espantri.
petitioner.
Yes, Your Lordship.
Yes, who is the other side? No problem.
No problem. 24. No?
Yes, sir.
2 weeks. Yes.
Deploy.
Please, Lordship, I beg to make a joint mention of item number 8. Lordship, I pray for 2 weeks time. It's a joint prayer,
mention.
Lordship.
Joint prayer, Lordship.
At the joint prayer from the made with the parties. This is better after 2 weeks. Yes.
Much obliged, Lordship.
Please, Your Lordship. I beg to mention item number 22, Your Lordship.
Yes.
Your Lordship, I pray for 2 weeks time in this matter, Your Lordship. The leading counsel, Your Lordship, she is out of station.
Object, Your Lordship.
At the request of the respondent, list of the 2 weeks. Item 22. Yes.
Oblige.
Beg to mention item number 21.
21. Yes.
I'd like to plead 2 weeks time.
You are mentioning on behalf of the
Petitioner,
petitioner. And what do you want?
I beg to plead 2 weeks time.
No objection.
Much obliged.
Okay. Yes, that will be recorded. You have any objection? Yes. At the request of petitioner. Yes.
Lordship, I beg to mention item number 13 on behalf of the learned AG.
Item 13. This has not been mentioned till now. Yes.
Not yet. I pray if this matter may come up after 2 weeks, Lordship.
No objection. No objection. So at the request made on behalf of the learned Advocate General appearing for the state respondents, this matter after 2 weeks. Yes.
I'll oblige. I please, Your Lordship. Lordship,
Yes.
I beg to mention item number 14, Lordship.
14.
For respondent number 1 and 2.
Yes.
I have no objection, Your Lordship.
I am for the respondent number 3, my lord.
You also not have any objection. When petitioner doesn't have objection.
Okay, respondent 1 has.
This also just have the request made on behalf of so and so. 2 weeks.
Lordship.
This is matter. Yes.
Oblige.
May it please, Your Lordship. Lordship, I beg to mention item number 18, Your Lordship. Item number 18. Lordship, I pray for 2 weeks time, Your Lordship, as the conducting counsel is out of station.
You are making a
Petitioner,
mention on
Lordship.
behalf of the petitioner.
Yes, Your Lordship.
Your Lordship, I am for the responding, Your
No
Lordship.
objection.
Your Lordship.
Right. 2 weeks. Yes.
May it please Your Lordship. Your Lordship, I beg to mention item number 20. I'm praying for 2 weeks time, Your Lordship, as the conducting counsel is on sanction leave.
Who is the conducting counsel?
MF Qureshi. Sir MF Qureshi, Your Lordship.
Why? He is already in festival mode.
Pardon, Your Lordship.
Yes, who is for the respondent?
Lordship, I'm presenting on behalf of Ms. N.G. Shalal, Legal Aid Counsel.
And you are objecting?
Your Lordship.
No, not objecting. When you want it?
Similar prayer is made for item number 7, Your Lordship.
No, no. How long you want this one? This
2
matter?
weeks. 2 weeks time,
2
Your
weeks.
Lordship.
First one 2 weeks of the request of the petition. That item 20. And yes,
And
What
also
else?
for item number 7, I'm for the respondent number 5, Your Lordship.
who is? Item 7 has already been adjourned.
Obliged, highly obliged, Your Lordship.
Yes.
Supplementary cause list, item number 1.
Yes.
My lord, the petitioner was married in 2001 and she lived in Punjab in her marital home, matrimonial home for about 1 year. When a girl child was born, the in-laws started torturing her and they had thrown her out of the house. So she came back to her parental home in Harijan colony here. Then COVID came. Thereafter, there was an attempt to reconcile the parties, but it failed. So she filed one CR case before the magistrate under the PWDV Act.
Claiming maintenance.
Paying for maintenance at,
not 125 petition.
no, under the Domestic Violence Act, along with some IPC sections like abandonment. Now the court below issued notice. The opposite parties received the notice. They came, they took court bail, and they filed one application challenging the jurisdiction of this court. Then the hearing was had taken place. The court heard both parties. From my side, I had emphasized that the jurisdiction is there under section 27 of the Act. And the first choice there says, wherever the victim, the aggrieved person resides, the magistrate under whose jurisdiction the victim resides, that magistrate will have the jurisdiction. Now the hearing took place on 16/7/2024. Till today, no order has been passed. That is my grievance. Meanwhile, my hardship have aggravated.
Where is the order which shows that hearing has been conducted?
My lord, page 20 was the date when the
Why you were before this court?
16/7.
You do not have a remedy before session judge.
That order has not been. That order is not there.
No. Why you are before this court?
That the court below may be directed to hasten pass the order immediately and proceed further.
Why you have not approached the session judge? Why you are here?
There was no order to appeal against actually to the session
Nothing
judge.
can be made out from your petitioner. Where is the order? Where is the order?
Order is not there from page 20 to less. You see, it's all for order. Order has not yet been
What
passed.
is this? What kind of order is this? These are all downloaded from.
That is my grievance, my lord. Order has not yet been passed.
These are what evidence, mister?
That order.
You come with certified
It has
copy of
all been
orders.
fixed for order.
You come
for
with certified
order,
copy
but
of the
order
orders.
has not been passed.
You
so far.
come with certified copy of these orders.
Okay, man.
List after 2 weeks.
Obliged.
What kind of petition you are filing? The request of the petition on list after 2 weeks. Yes.
May I please? My lord, I am here before your lordship. My bail has been cancelled by the London Special Judge and DPS. My lord, I was arrested on.
Why bail matter before here?
Lordship, as per the roster.
Bail is not the roster of this court.
No, this is a criminal petition, your
Criminal
lordship.
petition.
Criminal
But it
petition.
concerns bail.
Lordship, it came before. Lordship, can you have the roster? Roster, your lordship, as per the roster, your lordship will criminal matters including revision, appeal below 10 years, and miscase.
No, that is okay, but then come to the roster of the other court.
Then lordship kindly have the roster of max appeal, bail matters, both regular and
bail matters.
Bail matter. So this will not come under bail, your lordship, because they have challenged the order of the order of cancellation passed by the
But
London.
then does it not concern bail? Anyway, see, this court will not have a problem. But then see the recent decision of the apex court you have seen. You have seen the order passed by a court.
In fact, lordship, I was carrying that decision, your lordship, in I was carrying that decision, Your Lordship.
Anyway,
That's why on the basis of that decision which I have, that is why you was pleased before Your Lordship.
just because 528 or 482 is cited doesn't mean that it is give decision.
Because that the
See,
order
subject matter basically is the main thing which should be considered. Anyway, there is no problem for this court to proceed with. If it is not termed, the order passed by this court is illegal. So that is for you. You take this. Anyway, yes.
My lord, I was arrested on 31st/5/2023 in connection with Molai PS case number 47 under NDPS Act for contravention of the NDPS, provision of the NDPS on 21B for intermediate quantity, because it was alleged that suspected heroin was recovered from my possession. My lord, I was arrested on 31st/5. Since charge sheet was not filed, I was granted default bail on 1st August 2023 on certain condition that I should not commit similar offence, and other condition that I shall cooperate with the investigation. And accordingly, Your Lordship, I was cooperating with the investigation. Charge sheet was filed in that case, and trial started. I was participating in the trial also. Unfortunately, after 1.5, almost more than 1 year, Your Lordship, another case was FIR was lodged against me, and I was arrested subsequently on 26/9/2023. Thereafter, Your Lordship, I was arrested. I was remanded to judicial custody. In the meantime, Your Lordship, the informant, the complainant of the second case, that is Lumdingiri PS case number, that is also intermediate quantity, Lumdingiri PS case number, the informant, he filed an application before the London Session Judge for cancelling my bail.
Because the stipulation was that you should not
involve
yourself in this thing.
Yes, commit. So, my lord, the complainant filed the petition. Who has no concern, he was in fact the informant, and he was not affected party. The cancellation of bail should have been come from the IO.
State authority, it doesn't matter.
But I just raised an objection, so cause I raised this aspect also, but I maintain, my lord, that I have not committed any offence.
No, but then once you are found involved, you are arrested. That is good enough.
Yes, my lord.
We do not have to look here for proof beyond reasonable doubt. The trial has to be held, and thereafter that there has to be finding.
Yes.
Then this stipulation of this condition will become meaningless.
Yes, my lord. But without calling for the record, I'll just take your lordship to the impugn order.
No. Are you denying that you have not been?
No, I have denied, my lord. I denied in the so cause and in the objection that I am not involved, and I have been.
No, but then you have been arrested, isn't it?
I have been arrested.
That is good enough. What more is needed?
But lordship.
So see, this is a bail condition. Yes. You just cannot say that to hold that you are guilty, there must be some completion, of trial. Then only I can say it can be said that you have violated that stipulation.
Yes, my lord. But the record has to be called, and the learned, while before cancelling the bail, the learned special judge should have record its satisfaction. Only because FIR has been lodged, it does not mean that I have committed the offence. And my lord, the special judge has not even perused the FIR.
According to you, at this stage, what would mean you have committed crime?
According to me, my lord, as of now, allegation is there, and even that charge sheet has not been framed, your lordship. The charges has not been considered in this new case, second case. There is no even opportunity has to be provided to me before.
What stage it can be said? So far as the stipulation,
yes,
condition of bail is concerned, you are saying that if you are found involved in subsequent case is not sufficient.
Not sufficient.
For some law.
My lord. Daulat Ram.
Yes.
Paragraph number 4.
Yes.
My lord, rejection of bail in a non-bailable case at the initial stage and the cancellation of bail so granted have to be considered and dealt with on different bases. Very cogent and overwhelming circumstances are necessary for an order directing the cancellation of bail already granted. Generally speaking, the ground for cancellation of bail, broadly illustrative and not exhaustive, are interference or attempt to interfere with the due course of administration of justice, or evasion or attempt to evade the due course of justice, or abuse of the concession granted to the accused in any manner. The satisfaction of the court on the basis of material placed on the record of the possibility of the accused absconding is yet another reason justifying the cancellation of bail. However, bail once granted should not be cancelled in a mechanical manner without considering whether any supervening circumstances have rendered it no longer conducive to a fair to allow the accused to retain his freedom by enjoying the concession of bail during the trial. This principle, it appears, were lost sight of by the High Court when it decided to cancel the bail already granted. The High Court, it appears to us, that overlooked the distinction of factors relevant for rejecting the bail in a non-bailable case in the first instance and cancellation of bail already granted. My Lord, based on this judgment, my Lord, the Honorable Kerala High Court also has.
What is said here?
My Lord, very overwhelming and supervening circumstances is required.
Of the court.
Yes, my Lord.
So that is satisfaction of the court. It is
Satisfac-
not that you see the court has passed the order without taking into consideration any material. If the FIR
Yes.
itself satisfies the court, that is good enough.
Then FIR has to be called, at least the FIR. My Lord, there is no whisper that even the London special judge has gone through the FIR also.
You take instruction.
May it please your lordship. Lordship, in fact, our instruction is not required. The fact remains, your lordship, she has been granted bail. There is a stipulation, your lordship, that she should not commit the offence, your lordship. So that is the condition which has been violated because after being released on bail, she was involved. She was arrested by the police in another case, your lordship, and there are 3 cases registered against the petitioner, your lordship. One in 2015, your lordship. One is 2015, yes, and 23 and 20.
No, but then the thing is that what material was placed before the court
Lordship,
when this order of cancellation was passed?
Lordship, she is a habitual offender.
No, what are the materials before the
Lordship, kindly come to page, the order passed by the learned session judge. Lordship, kindly come to page 29.
Yes.
Lordship, kindly see the stipulation in the bill, yes, that she shall not commit similar offence. Yes. Then Lordship, kindly see, then the application filed by the IOL, by the Lordship, kindly see, Lordship, kindly come to page 20, para 8.
Page 20, 20.
20, your lordship.
Yes.
Lordship, she was also involved in that case, that Maulai. Then Lordship, kindly come to page paragraph 5.
Show us the order that this was taken into consideration by the
Lordship. Then Lordship will kindly come to the order passed by the learned.
Yes.
Lordship, kindly come to page. Kindly come to page 33, Lordship.
Yes.
Lordship, kindly come that however.
Yes.
However, it may be said that accused was granted bail by the order dated so and so, and not by the order dated so and so. Lordship, then the judgment. Then kindly come to page 34, your lordship. The second case in which the accused has been arrested is also under the NDPS, which is similar to the offence committed.
The first part which you pointed out before that.
Lordship, kindly come, kindly turn back to page 33, your lordship.
Yes.
Lordship,
yes,
however, it may be stated here that the accused was granted bail by the order dated so and so, in bail application number so and so, and not by order dated so and so. There is a mistake quoted by them in the date, your lordship. Then the judgment of the Honorable Supreme Court has been quoted, your lordship. Then kindly come to page 34, your lordship.
Yes.
Lordship, kindly come to the second paragraph.
Yes.
The second case in which the accused has been arrested is also under the NDPS Act, which is similar to the offence committed in the instant case. One of the conditions laid down when the accused was released on bail in the instant case was that it should be she, Your Lordship, that she shall not commit similar offence. However, it appears that she has violated the liberty granted to her in the Maulai PS number case so-and-so, now registered as criminal so-and-so by in similar activities resulting in her arrest in connection with Lomdingjeri PS case number so-and-so, now registered so-and-so. Thus, the has made out a case warranting cancellation of bail. Accordingly, the bail. So that's all right. Good enough. What more do you say? If Lordship allow me, I'll place the judgment. She's a habitual offender. Lordship, kindly. What are the considerations, Lordship? Please go ahead. This is a very short, Lordship, a very short order of the Honorable Supreme Court. Lordship, Lordship, if Lordship kindly come to the next page 2. Yes. Page 2, Your Lordship. As regard the claim to release him on regular bail, we find that the prisoner has already been convicted, Your Lordship. I'm not. Then Lordship kindly come to page 3. Keeping in view. Keeping in view all the attending circumstances, especially the fact that the petitioner is alleged to be a habitual offender, we are not inclined to release him on bail. So, habitual offender, Your Lordship.
That is all right.
Then,
but then that is not with regard to cancellation, isn't it?
Lordship, yes. Then, Your Lordship, what is the recurring cancellation, Your Lordship? Lordship, kindly come to para 11 of that judgment at page 228, Your Lordship. Lordship is with me. Page 228, Your Lordship, para 11.
Yes.
Law is well settled by a catena of judgment rendered by this court that the constitution for grant of bail and cancellation of bail, cancellation thereof are entirely different. Bail granted to an accused can only be cancelled if the court is satisfied that after being released on bail, the accused has misused the liberty granted to him, flouted the condition of the bail order. Can you see, Your Lordship, this too?
Yes, yes, yes.
Has misused the liberty in this case, Your Lordship, recommits the similar offence, flouted the condition of the bail order, Your Lordship. There is a stipulation in the bail order, Your Lordship, that she should not commit a similar offence. So this, in my humble and respectful submission, Your Lordship, this judgment will squarely cover this case. Then, Your Lordship, another decision, Your Lordship, of the Honorable Telangana High Court, Your Lordship. Lordship, this is, we just got from the website of the Honorable High Court of Telangana, Your Lordship. Yes. Lordship, kindly come to para 5 of that judgment.
Yes.
The notice is served on the respondent number so-and-so. There is no representation on this. As stated by the learned public prosecutor, crime number so-and-so was registered against the respondent, which shows that he has violated the condition imposed by this court so-and-so, and this court deemed it appropriate to cancel the bail granted to the respondent number so-and-so. So, Lordship is very...
It's okay. It doesn't load down any proposition. It doesn't lay down
a coordinate bench of this honorable court, Your Lordship.
Now, this is what coordinate bench of this court.
Lordship.
So you want to bind the court now, isn't it?
No, that isn't my intention, Your Lordship. Just yes. Lordship, kindly come
that should be your intention. Why
not? No, there is no. Kindly come to para 5, Your Lordship.
Yes.
The essence of cancellation of bail is rooted in the fact that the accused person has violated the bail condition, or that while on bail he has indulged in a similar kind of offences. So, Lordship, this judgment, Your Lordship, by a coordinate bench of this court.
He has given indulgence to similar kind of
Lordship. So, my humble and respectful submission, Your Lordship, no cases made out, Your Lordship. The order of the landed special judge is required to be maintained, Your Lordship, considering the fact that the petitioner is a habitual offender, Your Lordship, and His Lordship is aware, Your Lordship, that drugs. A murderer commits one murder or two murder, but drugs, Your Lordship, it kills hundred and thousand of people, Your Lordship.
The cancellation of bail is in Meghalaya IPS case number 47.
Lordship, yes.
And where she is found to be involved again?
Lumdingiri PS.
Lumdingiri PS, Your
What is the
Lordship.
case number?
Lordship,
Where do we get it?
Lordship, kindly come to page 34 of the impugned judgment, impugned order of the learned special judge.
Yes.
Lordship, kindly the last sentence from below, Your Lordship.
Yes.
In her arrest in connection with Lumdingiri PS case number so and so.
And what is that first case you said?
First case, Your Lordship, that is Meghalaya PS. It is there on the, Your Lordship. 1, 2, 3, 4, 5. 5 sentence from below, Your Lordship. However, Your Lordship.
Which
Lordship, page 34, Your Lordship. Page 34.
Yes.
Lordship, 5 sentence from below. However,
yes.
However, it appears that she has violated the liberty granted.
No, that is the answer one. And before that, she was involved in 2 cases only.
Lordship, in 2015, Your Lordship.
Yes, that is where is that?
That is Meghalaya PS. No, Your Lordship. Lumdingiri PS case number 34 for 2015 under section 21, 25 NDPS.
No, it
But
is not here.
It has not been reflected
Where,
here, Your
where,
Lordship.
where do we get it?
Lordship, this is from the record we are keeping, Your Lordship.
It is not mentioned.
It is not mentioned,
Was
Your
not
Lordship.
placed. My lord, I'll just place one more judgment.
What is the
my lord,
see? This is we have limited jurisdiction. Not like unlike appellate court, we are not going to replace
My lord
it.
may not consider also. Just for
This is unnecessary.
this is similar. This is a similar.
Yes. This is Kerala.
Yes, my lord. Paragraph number 10, my lord. My lord, be that as it may, the question is whether the order of a special court cancelling bail granted to the petitioner can be sustained or not. As rightly pointed out by the learned counsel for the petitioner, the order of a special court, relevant part has been extracted above, does not contain even a subjective satisfaction that the petitioner has prima facie committed the second offence. Registration of the second crime ipso facto need not result in cancellation of bail. Of course, the condition is that the petitioner should not involve in any other crime while on bail. Even so, cancellation of bail being something affecting the personal liberty of person, the court should have undertaken a summary inquiry as held by the apex court in Dataram. The special court should have called for the materials concerning crime number such and such, and after considering such materials alone, a finding should have been rendered. Now, paragraph number 12, my lord. As stated,
when you were arrested in that subsequent case?
After 1 year and 26
No,
9
when? Which date?
26 9 2024.
26/9/2024.
Yes, my lord.
And did you move bail in that the new case?
No, I have not moved. I am in custody in that particular case.
You have not moved.
I have not moved.
Okay, 29/2024.
Yes. I have not been granted bail in that case, my lord. I am not sure, my lord, whether I have moved or not, but bail has not been granted in that case.
Have you moved or not? That is also important, quite relevant here.
Yes, my lord, that is, I am not, because I am not.
Anyway, you have not been granted.
Yes. But bail has not been granted. I am still in custody.
Your detention,
yes,
in relation to the new case,
yes, my lord,
is authorized by the same court here?
Yes, my lord.
That is enough.
My lord, only my submission was that, my lord, that it was too premature to file the application for cancellation of bail.
Why?
Because at least the charges has to be considered in the second case. I should be provided an opportunity at least to place my grievances or my contention.
You have not been asked to show cause here.
No, show cause already filed.
But in the main case, my lord, I am entitled to opportunity of being heard before even the charge is framed, and that, my lord, it will have impact, because if the court will prima facie, I can satisfy the court, then I may get discharged also. So that has to be opportunity, proper opportunity has to be provided, my lord.
That is why this court has taken note of those things when you were arrested in that case.
Yes, my lord.
Okay. Okay, we'll pass orders.
Lordship.
Item number 3.
Apply, Your Lord.
Condonation.
There is considering the date of judgment order, there is some delay. Considering the date of the order, you will see there is some delay. But if I considering this for the purpose of this obtaining certificate and other, then it will be within the limitation. But we have given this because from the considering from the date of judgment, there is some delay.
How many days delay here?
18 days.
Yes. You are for the state.
Yes, my lord.
There is no private party here.
Private parties.
There is, my lord.
Private
But can you condone the delay without hearing the private party? You cannot.
No, my lord.
We have to issue
Let a notice.
in the condonation application. Since there is a private respondent, so we cannot. Mr. Artyom, right? Issue notice. Returnable in
1 week also will be done. I'll be taking.
Where party is from where? Private respondent is from which side?
Rebuy.
Returnable in 2 weeks. Mr. Sinkan Learned GA. FPS on behalf of the respondent number?
1, my lord.
1. The petitioners, the applicant, not petitioner. This should be applicant in the so and so. Also, Mr. Artyom, planning counsel for the applicant. The applicant shall take steps for service of notice. Take steps for service of take steps for issue of notice upon the opposite party number or respondent number 2 within 2 days. List after 2 weeks.
Okay.
Item number 4.
What is this matter about, Mr.
Lordship, this is Lordship will recall it was wrongly listed before the DV yesterday. That case, Lordship. This is a conviction 7 years under 376. Lordship.
Then no one appears.
No one is there, Lordship. That come after 2 weeks, yes. Then, Lordship.
Criminal miscase 22. This is a criminal appeal.
Lordship, criminal appeal. There is a delay also, almost 3 years.
Cannot
more than 3
dismiss
years.
also, that is a problem. Otherwise, 2 consecutive non-appearance. This court basically
let it come after
none appears. None appears for the petitioner in the criminal miscase 22.
Applicant, Lordship.
Applicant, none appears for the applicant. Mr. Andy Shulai, Learned AG is present with so and so for the state respondent. List after
2 weeks, Lordship. Apply, Lord.
Daily cause list, item number 1.
Lordship,
Yes.
I've taken steps, and but it seems that the registered AD card has not reached this honorable court. However, on checking the tracking app of the department, it says that it has been delivered. So I may be allowed to file an affidavit on service.
Yes, that will be that. Yes, Mr. Thaba, Manor Counsel for the petitioner submits that steps for service upon the notice upon the restaurant number upon the sole restaurant number has been issued by a registered post, but survey to post yet to be received. The petitioner shall verify the status of service of notice upon the respondent and file an affidavit to that effect. When shall I list it? List after
1 week.
After 1 week.
Lordship, same thing from item number 2 also.
Same situation.
Yes.
Same item. Yes.
Highly obliged.
Item number 3. Item number 9.
Yes.
I prepared a brief note, my lord, for convenience, my lord.
You prepared the note.
I prepared.
Helping the petitioner. Relieving him from burden. Yes. The 12 years, it was not subsequently modified to 10 years.
My lord. But I mentioned, my lord, that 19/5/2009, the third one in the first page, my lord.
Now, for applying the benefit of SCP, whether this fulfillment of promotional norms is required.
Is required, my lord.
That is a stipulation in the policy itself.
That is in the policy itself.
Is it correct? Now, a person's failure to clear it,
He'll defer it, my lord. When he clears, then only he'll get.
it will not be with the retrospective effect.
But here, in fact, the department has done a mistake, my lord. In fact, given undue advantage to him when I was going through it, my lord. Because when first ACP was deferred, my lord, by 6 years, second ACP should also have been deferred by 6 years. But second ACP was granted to him in time, my lord, in due time.
By covering up that.
So
But then is it not that once he clears it, then he will be given retrospective?
No, my lord.
It's not.
It's not.
That has been clearly stipulated in the scheme. So only thing is that we can make out a case just going to the provisions of the scheme.
Well,
here, my
my
lord,
lord, I do not understand, because on last day my friend has submitted some judgment, but that is altogether different something.
Some judgment was submitted here,
my lord. The Satish Kumar judgment has been placed. That is
Oh,
something.
so that is the matter which you said is covered case.
This is, I could not understand how Mr. Jha is
It's not a
saying that.
covered case.
This is altogether different issue.
What is there is no judgment here, Mr. Jha.
only the given to the junior.
No, but then there here you have to supply it to the court, isn't it? Don't think it is there. No judge.
Mr. Babu. Now, how department is done, my lord? Because ACP can only be given if there is no promotional avenue. Here, he has been given 3 ACP and 1 promotion also.
Is it?
Here it is a case that the 10-10-97, which was it's a grade which is from rifleman to Havaldar, the redesignation of the post. That has not been implemented as of now. Nothing on the record. It has been brought that when it was implemented, then only, my lord, the first SAP would count it from the date when that 10-10-97 was implemented. If I have been given a Havaldar, rank of Havaldar at the initial stage, then the SCP with regards to the another, if promotion is not there to the NAPSUD,
But then SCP
if the
basically guarantees benefit
promotion,
in absence of promotional revenue, presence of promotional revenue, isn't it? Now, once you have it, then definitely the scheme also will be applied accordingly, isn't it?
promotional will be counted, my lord, when the if the initial rank, that was the redesignation of the post of the category at the initial stage of the recruitment from rifleman to Havaldar, along with the pay scale also. If the Havaldar,
say just a minute, just make it simpler. This court has very understanding is very little.
No, my lord.
The thing is that the SCP basically ensures MSCP modifiers that there will be at least 3 minimum upgradation, 3, isn't it?
10, 20.
At least 3. Now, say supposing by the time when this scheme came into force, a person had got the benefit of promotion once, whether that minimum 3 will have to be given to him or it will come down to 2.
That has to be 3.
No, that will come down to 2. I'll point out that.
So
that is in the rule
that is
itself.
what is the thing. If we understand that, if we can get this thing clarified, then that is enough. So you have to see that way only. Now, if Dr. Mojika says that you have been given benefit 4 times, that covers. Because scheme is for the entire service tenure, you see, entire service life. So that is what you see in that line, and just come back to us.
On page 19, my lord, in my affidavit, the scheme clearly says, my lord.
Let him just clarify the concept. Probably he is arguing under that misconception that even if he's this thing, like say supposing schemes after he's been given 1 benefit, then even then he will be entitled.
He gets a promotion, then he'll not get second, he'll only get third.
If he finds that there is nothing, then good sense may prevail. He may say, I will not pursue the cases. We'll keep your synopsis in the record. Just pray for the petitioner. This is matter. When shall we do it?
After a week?
After 2 weeks. Bye.
Same, my lord.
9, 10 are connected.
Connected.
Oh, what's the same? Not same. So same order.